Hello, Colorado Realtors. I'm Scott Peterson. Great to see you, and thank you for joining me for another edition of Legal Bites. I hope everybody's having a fantastic Colorado summer and enjoying some of the hot weather, but we've had a lot of moisture this year, which has been great as well. So I'm coming to you with Legal Bites on cash offers and loan changes. And the reason that I put this topic in here and wanted to get on this today was because I'm getting a lot more questions and inquiries, primarily on the hotline, from brokers related to the interface of making a cash offer versus an offer that is cash but doesn't have, or let's say an offer that doesn't have a loan termination or loan condition involved. And that's an important piece of things in terms of the distinction. So I want to talk a little bit about that. And then I'm also going to talk about another piece of inquiries related to this topic, and that's a buyer changing lenders or moving in a different direction with regard to their loan. So first of all, I need to set up a couple of definitions here, and these come under paragraph 4. Both of these two intersect in paragraphs 4 and 5. And paragraph 4 speaks to the concepts of good funds. At the end of the day, the buyer's obligation in the contract is to show up at closing with good funds. And good funds is defined as an electronic EFT or a cashier's check, which would be a wire transfer cashier's check, something along those lines. But they've got to be able to produce those good funds at closing. But paragraph 4 also has this indication related to the buyer's representation of their good funds and when those are going to be available, or are they currently available. And so I'm going to jump down here in my PowerPoint, but that speaks to the cash at closing. So if you go to paragraph 4.1, which is the chart with all of the dollar amounts in it, there's earnest money, and that's always going to be the earnest money deposit. And then in some cases where there's going to be a new loan and there's a loan condition that's going to say, new loan amount, and there's going to be a larger dollar amount presumably, and then there's that little bit, the cash at closing. And so on a pure cash deal, what you're going to have is the earnest money, cash at closing, and those are going to add up total to the purchase price, right? And that's certainly appropriate in the case that it is a true pure cash deal. The buyer has those funds, and in that case they are going to be checking, presumably in paragraph 4, just below paragraph 4.1, they're going to check the box that speaks to the availability of funds. And that's where the buyer discloses to the seller that they have the funds in an amount of cash at closing. They have the cash ready, and it's immediately available, verifiable. They're ready to go with that money. And they're either going to say, yes, they do, or no, they don't. And saying no, they don't, if you're a seller or a listing broker, ought to invoke some additional questions. In other words, is this a cash deal that you have this money and available, you're ready to go? Is this going to be a situation where you're going to be, converting some reasonably liquidated funds and coming to cash? Or is this a cash deal where you're not essentially exercising or taking any loan conditions? And so in the event that you're essentially, with a buyer, you're making a cash offer, but you're deleting the loan conditions deadline, the loan application and loan termination deadlines, but you don't have the cash available. In other words, your buyer is going to be still seeking a loan, but they're not taking advantage of the loan contingency. Paragraph 5.2, that loan termination deadline, which is very, very broad, they're basically in that case telling the seller, hey, we're taking on the risks of obtaining a loan all by ourselves. But it is still super important from a disclosure standpoint, from a good faith standpoint, that buyer is checking the appropriate box under paragraph 4 that says, we do not represent that we have this money available, verifiable, and ready to go as of the date of this contract. But we're taking the risk on ourselves. And so understand that that's an important distinction for your sellers to be considering, as well as for buyers to understand when they're making that offer. If they're making a cash offer and they're still going to pursue a loan, or they got to get financing from rich Uncle Jimmy, or it's someplace other than in a place that it's immediately available to them as of the day of the contract, that they're going to be able to bring good funds at closing as defined above, but they're not taking a condition or contingency that if they can't somehow get those from a lender or some third party, then that's going to be essentially the forfeiture of their earnest money in that case. And so that box in 4.1 is super important for both the seller and the buyer. The buyer's got to be making a good faith representation related to the availability of those funds as of the day of contract for the cash at closing, and for the seller to go, what's going on if this is not available? What are we trying to accomplish here? The last thing I want to talk about in this is the appraisal, and I'm getting a lot of this where a buyer is they are making essentially a cash offer, and all that means is they want to pursue a loan on their own terms, but they are waiving their loan contingency. They're waiving the loan application and loan termination deadlines. But if they intend to get a loan, they need to make darn sure that they're getting that they have an appraisal contingency, because in that case, if they're trying to get a third-party loan, unless it's a secondary market loan, any conventional lender is going to require some form of an appraisal. And so if they're also waiving their appraisal, now they don't have even a right to appraise, let alone object to the appraisal or terminate based on the appraisal. And so I'm getting a lot of that situation as well, where they're anticipating that they're just going to take on the burden of getting the loan on their own terms, but they're also waiving their appraisal contingency, and now they're required to get an appraisal, but the seller's saying, hey, I'm not going to let you appraise. You don't have a right to appraise. So make sure as you're navigating these weird times that we're currently undergoing, where buyers are doing insane things, that they are doing it and they're doing it with your advice that they're doing something insane, but moreover, that you're preparing the contract in a way that doesn't otherwise forfeit their earnest money or subject them to an ability to get an appraisal. I know they're having to agree to things that they wouldn't normally do right now, but be very, very cautious about that, and I am getting a lot of issues with the intersection of all of that. The last thing I'm going to mention this is loan changes. I'm getting a lot of calls as well, buyers who are providing a loan, pre-approval or some lender letter at the front end of the transaction, and then they want to move along to a different lender. And sometimes sellers say, well, I don't think they can do that, or listing brokers say they shouldn't be able to do that. Well, in paragraph 4.5.2, it describes the fact specifically that buyer may select financing. And it says that buyer may pay in cash. So even if they have a loan contingency, if they just want to pay in cash, that's fine. They don't have to pay with loan proceeds. They may pay in cash or select financing appropriate and acceptable to buyer, including a different loan than initially sought, unless it's restricted by the loan limitations or additional provisions. So what that's essentially saying is that if a buyer's got a conventional loan limitation, in other words, they've checked the box conventional, but they don't have VA or FHA as an example, if they intend to move to a VA or FHA, they don't have the ability to do that because that's restricted by the loan limitations. But if they want to move from conventional to another conventional, or conventional to cash, or conventional to something that is not restricted by loan limitations, or there's not an additional provision that's been agreed to that says, buyer agrees to pursue only this type of loan with this lender specifically, then the buyer's free to do that. And the seller can't object. This doesn't create a seller's right to terminate the contract because they're using a different lender, any of this stuff. And I think I'm getting these questions because sellers are taking a contract, they're getting subsequent or backup offers, maybe for a lot more money, and they're looking for any way they can to get the buyer, or kick the buyer out of the contract. Well, this isn't the way to do it. As long as the buyer's not moving to a different loan type or outside of their loan limitations, then they have every right to modify or move to a different lender or bring cash in lieu of loan proceeds. So anyhow, just wanted to point those things out. If you have questions more specifically, always feel free to call the Car Legal Hotline. We're available from 9 to 12 and 1 to 4 Monday through Friday. And it has been busy, busy, busy for a long time now, but really picked up over the last several months because of some of this crazy market stuff that we're all enduring. So anyhow, guys, keep enjoying your summer. We will see you again on the next edition of Legal Bites.